Okay. Kia ora tātou, ko Graeme Colgan toku ingoa. Welcome to this quickfire webinar organised by the New Zealand Labour Law Society and entitled Employment Law in an Uncertain Environment, Utopia or Dystopia. I hope the Zoom medium we're using is not dystopic, but I suspect it would be rather more utopic to be in a real room together. But if the current dystopia has a silver lining, it's that it has enabled us to participate equally wherever we are, and equity in employment law has to be a good thing. We are more than 100, and some people are participating from beyond New Zealand. We're going to be speed dating today's presentation. There will be 10 presentations from 10 presenters. Each of them has 5 minutes, and each of them has theoretically one PowerPoint slide to cover a variety of both dystopia and utopia. I suspect some people have exceeded their one PowerPoint limit already. I'm going to introduce each speaker briefly, and then, like the moderator from Fox News in the recently and eminently forgettable presidential debate in the US, I'm going to try to retain control of the short time they have. I promise that I will not shout, "Will you shut up?" We have a question and answer facility, and while I encourage you to send in your questions during the presentation using the chat button at the bottom of your screen, please indicate which speaker you'd like to respond, speaker or speakers you'd like to respond, and we'll address those questions at the end of the 10 presentations. And finally, please try to keep your mic muted unless you're speaking or wanting to speak very shortly. It cuts out all sorts of interference and makes it better for others. So, first up is Professor Gordon Anderson. Gordon is Professor of Law at Te Herenga Waka, Victoria University of Wellington, as it's still called. His research has focused on the evolution of labour law in New Zealand over the last half century, and more recently on the character of labour law in common law jurisdictions and on how the law is positioned to the changing futures of work. He's an author of Employment Law in New Zealand, and most recently with Douglas Brodie and Joellen Reilly of the Common Law Employment Relationship. Gordon's topic is structural integrity, employment law, and the pandemic. Gordon.
Oh, right, thank you, Graeme. Hello, everyone, and welcome to the seminar. Hopefully, I'm well within the 5 minutes. I got the right number of words. And I sort of saw my paper as possibly something of an introduction to what everyone else is going to say. The COVID-19 pandemic and its consequences have, I think, provided a real-life stress test of the regulatory architecture of New Zealand's labour relations and its labour law, and also the associated other areas of law such as social welfare law. So what we hopefully will see once the results of what's been going on are collated and properly analysed are the weaknesses in our current law, and in particular the weaknesses that may affect the ability of the law to respond to future crises. As I said, this brief bit of mine is something of an introduction to the other speakers, because I'm really just posing the question of whether New Zealand labour law has the necessary resilience to cope with the COVID-19 panic. But other people will be looking at some of the details of that. But one of the reasons I think it is important is it's a lot, I think, will be able to be learned from this particular episode as we face upcoming things on the horizon, such as climate change, the AI revolution, and things like that, which one rather suspects will start speeding up and coming towards us a lot more quickly than we realise. The other thing, of course, is in looking at the COVID crisis, we have to appreciate it's only a few months old, and that we also have been remarkably successful in containing the impact of the pandemic. And as a result of that, our labour laws, of course, haven't been placed under the same stress as is occurring in many other countries. And it's also not clear, I suspect, just what depth of legal regulation we might need to cope in a future situation. We did show that we had the legislative flexibility to move quickly and to put in place things like income support for both workers and businesses. But there is a difference, of course, between reacting in an emergency and having the embedded social framework that you might want in the longer term. So while I think, in broadly speaking, New Zealand's employment law and labour law seems to have responded reasonably well, although I think some of the coming papers on the authority and things may give us another, well, a different aspect to look at that, different lens to look at that through. What probably has been fairly obvious is that weaknesses in the law have been shown more clearly as a result of this. One in particular is the very limited degree of protection we have in New Zealand against redundancy, both in labour law and social security law. And of course, in the absence of something in a collective agreement, most New Zealanders don't have any particular safeguards or economic protection against these sort of things. What we have seen, of course, is the standard labour law being upheld. Labour law itself wasn't changed. The courts and authority are reaffirming that you can't unilaterally vary contracts, that you can't force people to take leave before it's due, that proper consultation is still required, and those sort of things. But I think probably there are two, apart from the point about redundancy, there are 2 or 3 other things that will emerge. And I think at least one of them will come up in the next speaker with the question of access to justice. But the other area I think that's probably seriously showing up is how we're going to deal in the future with artificial intelligence and workplace surveillance. And that, of course, is also the subject of a later speaker. Probably the one point I would make at this stage is that a worker's right to a private life is probably one of the least developed areas in New Zealand law, and it's one I think that's in need of significant development. So sort of drawing all this to a close, I think I'd refer to a recent Guardian comment by Nick Colgan, who was talking about Sweden, which I think he referred to as a sort of Disneyland of the new right. But he did make one key point, I think, and where he said, Sweden may not have been spared the storm, but it has lessons on how to shelter society until the storm passes. And in that article, he made the point that Sweden was able to achieve this because of the depth of its social protection. And probably 2 features in particular are noticeable. One was the generous amounts of sick leave that are able to be accessed by Swedish workers, which of course means that at least many of them were able to stay at home during the crisis and weren't forced to work through economic necessity. And secondly, the social insurance system, which seems to provide a much stronger degree of support for those in transitional employment than we've usually had in New Zealand. So while New Zealand may have been able to rapidly move to provide economic support, that's quite different than having the ethos about that support embedded in social security system. And indeed, I think New Zealand's got quite a long way to go in that respect. And hopefully I'm within time, Graeme.
Most exactly. Thank you, Gordon, for that thoughtful and thought-provoking contribution. Our second speaker is John Goddard. John began his life as a lawyer originally in Christchurch with a practice, I think, John, that related to the legal aftershocks attributable to the earthquakes. But John is now in Wellington. He went to the independent bar as a barrister earlier this year at Lambton Chambers. John's an approved provider of civil legal aid, and he says for his sins, he is a deputy convener of a lawyers standards committee, although I suspect that's also for the lawyers' sins who come before it. John, your contribution, your topic, as Gordon alluded to, is access to justice.
Thank you very much, Graeme. Hopefully everyone can hear me. In keeping with this theme on coronavirus, I've managed to acquire a cold, so fingers crossed that what I say is relatively clear. Anyway, picking up from our conference in Wellington in November of last year, I realised shortly afterwards that I no longer wanted to work as an employed solicitor, so I promptly resigned and then thought, well, what should I do next? So I decided to go out to the bar as a barrister sole. While I was a litigator, I had often argued that human rights, and specifically the United Nations Guiding Principles on Business and Human Rights, were relevant to claims for general damages against private insurers. This argument was unequivocally rejected by the High Court, who would not permit the purity of the common law to be contaminated with amorphous human rights principles.
Yeah, good, good. How can I help?
When I went to the bar, I was setting up a business in my own name, so to avoid feeling like I was...
Did you get my email which just gave you
Oh,
the dates?
Online there. Somebody's talking on the phone.
Oh,
Can we make sure that phones are muted, please, so we don't have any interference? Thank you. Sorry, John, go on.
All right, and
no, that's all good. I
decided that I would commit to working in accordance with the guiding principles.
I'll just look that up for you.
So, just to recap briefly, the UN Framework on Business and Human Rights requires state agencies to protect human rights, businesses to respect human rights, and states must provide dispute resolution mechanisms which are legitimate, accessible, predictable, equitable, and transparent. Embedded within this framework is a requirement for state and non-state agencies to undertake human rights due diligence, i.e. assess any adverse human rights impacts which occur as a result of activities undertaken by a particular business. Because I work predominantly in the areas of employment and insurance law, where there are often significant disparity in resources between various parties, complying with the framework for me meant becoming an approved provider of civil legal aid. Anecdotally, I had heard that most practitioners who used to provide legal aid no longer did so because the administrative requirements were so cumbersome. However, I did not see that as an excuse which would let me off the hook. Previously, the application had 22 sections and ran to some 90 pages. However, due to the Ministry of Justice seeking to increase the number of providers while not increasing rates of remuneration, the application form I filled in ran to a mere 28 pages. It took the ministry 3 weeks to process my application. Since then, I have had legal aid approved for matters which have been or will be heard in the Employment Relations Authority, the Human Rights Review Tribunal, the Canterbury Earthquake Insurance Tribunal, the District Court, and most notably the Court of Appeal of New Zealand, sitting as the Court of Appeal of Tokelau. I've had legal aid refused on 2 occasions, but both of these decisions have been reversed when challenged. The remuneration rates for lawyers range between $116 and $144 per hour, about 30% of a standard commercial rate. For the consumers of legal services, they make a one-off payment of $50 and the rest of the costs, including expert costs, are met by the Crown. Some consumers end up having a loan that they have to repay, but the Ministry has discretion to wipe off part or all of that loan. For employment matters, the rates of remuneration are based on a very tight fixed fee regime, which provides $580 for pre-proceeding activities, $360 preparing for mediation, and $60 per half hour of mediation time. These rates compel a lawyer to cut to the chase, to focus on the key issues, and to keep all communications to an absolute minimum. I suggest that a broad adoption of this approach by lawyers and advocates could enable the employment institutions to protect labour law rights in accordance with the UN guidelines by providing quick and affordable access to remedy. And that's where I'm quite happy to leave my comments at this stage.
Thank you, John. I wonder how the necessity to be economical in communication squares with Section 4 of the Employment Relations Act that says that you must be responsive and communicative. But perhaps we'll come back to that in question time. Thanks again, John.
That's good.
Our next presenter is Andrew Dallas. Dr. Dallas has been a member of the Employment Relations Authority since November 2015 and Chief since August 2019. He holds a Bachelor of Laws from Canterbury University, a Master of Laws with First Class Honours from Auckland University, and a PhD from Griffith University in Australia. Before his appointment to the authority, Andrew was National Legal Officer for the Australian Coal Miners Union, Construction, Forestry, Mining and Energy Union, a lawyer in private practice, and earlier than that, a legal officer for the New Zealand Public Service Association. He's the co-author of an Australasian text on good faith bargaining, has held several government appointments in New Zealand, including Pike River Expert Reference Group, the New Zealand Mining Board of Examiners. Andrew is a visiting research fellow in Law Futures at the Law Futures Centre of Griffith Law School in Australia and the QUT Law School in Australia. Very well qualified to speak to us now, Andrew.
Tēnā koe, Graeme. Tēnā koutou katoa. I must shorten my biography in the next time I come to give a symposium. This is the second time I've spoken in my capacity as Chief of the Authority, and the first time in New Zealand. The previous presentation I gave was in Sydney in February, which seems like a lifetime ago now. Essentially, I took the opportunity to come and speak today because I think it was important that the authority talk about where it's been to and what it's doing in relation to COVID-19, and also generally because I'm on the executive of the New Zealand Labour Law Society and had no choice. So essentially, the participation of the authority in a technical sense started very early on with COVID, when we were called upon to facilitate bargaining between the New Zealand Blood Service and 9 DHBs. Strike notices have been issued by laboratory workers. The country was about to go into lockdown, and clearly based on what we've known then and known since, laboratory workers are quite fundamental to the response to COVID-19. So the authority, I granted the referral application for facilitation, and my colleague Vicky Campbell undertook the facilitation. And this is actually the first facilitation we undertook via Zoom, and delegates and representatives from both sides were at the table, obviously at different tables, and that resulted in a written recommendation, which we understand was accepted by the parties, albeit on a short-term basis. Now we're doing a presentation in a couple of weeks, Vicky and I, to a symposium by the Fair Work Commission. We're going to talk about facilitation of bargaining, and Vicky will be able to contrast the approach that was taken in the facilitation immediately prior to the COVID crisis and that crisis. Because obviously previously we'd facilitated in person, so the notion of doing it via Zoom was very new to the authority. How do I get to the next slide, Anik? Is that?
Yeah, I'll move it.
So I do apologise for having more than one slide. It was, yeah, anyway. So obviously we went into lockdown with the rest of the country. There was the tribunals and courts are recognised as essential services, and we were recognised ultimately by the Ministry of Business, Innovation and Employment, which is our host ministry, as being an essential service. But of course our staff were withdrawn at level 3, which made operations in offices very difficult. So we made the decision to return to our homes as well. So the authority became a virtual tribunal within the space of 2 days, which was pretty profound. There was a lot of activity as we sought to find mobile phones and computers and iPads and tested various systems to make sure that they would work remotely. Some of them didn't, and there was a lot of IT angst in the first week or so after we went into lockdown. We obviously had to adjourn all of our investigation meetings, which were set down. So we took the view that they're either going to be adjourned, or if possible, we could pursue them via Zoom, telephone, on the papers, or a mixture of those, what do they call it? Mixture of those methods or means. We placed new matters under direction, which we now call MUD files. And so the backlog that we're now working through is there's three aspects to it. So we have the files that were adjourned during the first lockdown nationally, and also the second Auckland lockdown. So we've had 2 lots of adjourned files in Auckland. Then we've had our matters under direction files, and then we've had our new files. And what we've sought to do is systematically move through the work in the way that you'd think a zip operates. So files come from different directions and are melded into lists for the members, in which case we actually resolve files in a sort of systematic way. What was remarkable we found about the lockdown was the authority was incredibly fit for purpose. When we studied our powers under the Act, we found that we didn't really have to do anything other than I had to issue a direction to members about how to deal with unsworn and unaffirmed affidavits. And the lawyers amongst you will be familiar with the amendments that went through to the Oaths and Declarations Act and the previous Law Society advice, which seemed somewhat cumbersome, whereas the authority seemed very nimble in comparison, and we were able to operate relatively effectively, certainly in relation to interim matters. One of the other things that developed was developing before the lockdown, but certainly has developed since the lockdown, is we now have an excellent relationship with the Fair Work Commission in Australia. I've had about 3 Zoom meetings with them in the last couple of weeks, and also the Workplace Relations Commission in Ireland. And the discussion points with them are around best practice. So how do tribunals, or industrial tribunals in our case, actually operate in a COVID crisis? And obviously the Australian situation is vastly different from ours in many ways because of the state-by-state response. And Ireland, being on the edge of Europe, sort of lurches from crisis to crisis in terms of its COVID outbreak. One of the things we found is that the Fair Work Commission is very innovative and is quite intent on moving to an online platform. The kaupapa of the authority has always been resolving employment relationship problems in communities, and because we weren't tested in the way that other tribunals have been tested to move to the online processes, we still are very committed and wedded to the notion of in-person investigation meetings.
1 minute, Andrew.
Coming to the last slide, Anik, and I do apologise for that. Obviously, many of you will be aware that there's several cases which have been issued which have found some prominence in the media and elsewhere. We sought to prioritise COVID-19 cases, essentially, which had wider application than just their own facts or their own circumstance. So obviously Gate Gourmet, which was issued by the authority on the 29th of June, that's gone on challenge and will be heard by a full court. Eastern Bays Hospice, which was issued on the 30th of June 2020, that's gone on challenge as well and also will be issued by a full court, heard by a full court. I suspect one or both of those cases may go on to the Court of Appeal and possibly the Supreme Court. And the last case is Solly's Freight, which was issued by us on the 8th of July. And I've just come back from a 3-day investigation meeting in Timaru where every traffic incident I seem to be involved with involved a Solly's Freight truck. So I think there's some attempt to schadenfreude there. But thank you very much for the opportunity to present today. Unfortunately, I have to return to my day job, so I won't be able to carry on with the symposium, but I wish you all the best with it. And mā te wā.
Thank you, Andrew. And just before you go, if you're going to shorten your academic career, don't abandon your Auckland LLM that I had the privilege of co-teaching you in.
Indeed.
Thanks.
Thanks, Graeme. Cheers. See you.
Thanks, Andrew. All right. Next, we're going to hear from Nicola Green. Nicola's interest is in the impact of the introduction of technology from a socio-technical systems perspective. Nicola's master's research explored the rapid adoption of telework by organisations following the Christchurch earthquakes. Since the beginning of COVID-19, Nicola's been involved in some working from home research in conjunction with Edith Cowan University in Western Australia and some consulting projects to other organisations. Nicola's currently a PhD candidate at Massey School of Management in Albany, although she is based in Christchurch. Her research project is around the impact of telehealth video conferencing services for key stakeholders in New Zealand, again with a human-centred approach. Nicola's work background is in human factors ergonomics with many years as a consultant to organisations. She holds degrees of Master of Philosophy and BA in Business Psychology, and her first qualification was in Physiotherapy, Occupational Health and Ergonomics. So Nicola is well qualified to talk to us about working from home in times of disruption and in the future, implications for workers and organisations. Nicola.
Kia ora koutou. Thank you for the invitation to join you today. I think my presentation will be a slight change of pace, but I really appreciate the opportunity to share my research. So COVID-19 saw around 30% of the New Zealand workforce move quickly to working from home. Before we had a single case of COVID in New Zealand, there was the largest mass exercise in remote working in global corporate history was taking place overseas. So the interest in working from home has been well and truly renewed. The research around working from home in a business as usual context shows workers who are able to work from home have more job satisfaction, have better performance, less work-family conflict and lower turnover. Mostly this is attributed to perceived autonomy. For organisations, working from home is good for productivity and retention. The best model of work is hybrid, that is when some time is spent at the office and some time at home. This mitigates the risk of the reported downsides of working from home, which is social isolation and difficulties with collaboration and communication. There's less research about working from home in times of disruption though. My master's research explored the experiences of 2 organisations following the Christchurch earthquakes when they rapidly adopted working from home in response to the disaster. The experiences with COVID-19 have highlighted similar benefits and challenges of alternative working arrangements in times of disruption. These experiences also impact on the way working from home might go in the future. Working from home as a tool for disruptive situations has been used primarily for extreme weather events like hurricanes in the US or snow events, or obviously the earthquakes that we've experienced in New Zealand. The benefits for organisations in these times are business continuity, and for workers, the flexibility and well-being benefits of being able to work from home. As you all may have experienced, some people loved working from home and others did not. Personal circumstances impact on working from home successes. Things like if you have a dedicated place to work and how many people and pets you share the house and the internet with. Some organisations also liked it and others did not. The head of Twitter has said that workers can work from home forever, while the founder of Netflix has said that working from home is a pure negative. I think the most interesting implications of so many people experiencing working from home is how organisations will now respond. Surveys within organisations in New Zealand and overseas have already shown that many people are keen to work from home and keen to continue to. And as the threat of COVID continues, there is obviously an imperative to be prepared to be more flexible where work can be done. As the previous speaker talked about, the preparation is really important. In my research, the transition back to business as usual was a critical period. People asked employers, if it was okay for me to work from home when you needed me to, why can't I continue to do so?
That's my supervisor if it happens.
There's somebody who doesn't have their mic muted. So working from home changes the employment and psychological contracts between workers and organisations, and the way organisations and workers respond to these changes will impact on its success. The 2 key areas are management and well-being. The literature has shown that management is often resistant to working from home, with concerns about loss of communication, collaboration and control. Managing people working from home requires trust and a focus on relationships. There's often a shift from a managerial style of needing to see the worker in the seat to measure productivity. Communication is altered and optimal ways to do this need to be worked out together. And, you know, in what circumstances do we email? When will we talk on the phone? When will we Zoom together as a team, or when will we meet in person? Well-being is another important consideration. Obligations of the Health and Safety at Work Act need to be met, and organisations need to work out how this will be done for workers at home. Physical workspaces are not always optimal at home, and this needs to be addressed to avoid discomfort and injury. Is a dedicated space a requirement for working from home? Who provides the equipment? How is the workspace assessed for suitability? How does this impact on privacy, which Graeme mentioned previously in his presentation, and other things such as who pays for the heating and the cost of the internet? So working from home has been found to increase the risk of social isolation and the blurring of work and home boundaries in some cases. These things can negatively impact on mental well-being, and organisations need to establish policies and procedures to manage these risks. Things such as organisational social support, and also the right to be disconnected from work and from devices. So just in summary, how well working from home is integrated into business as usual, if there is such a thing anymore, will depend on people's experiences of it during COVID-19 pandemic. And also whether organisations... Some dogs there, that's what happens when you're working from home. Sorry, to go back, whether organisations are prepared to work with workers to adjust their structures and their ways of working will help determine if working from home is dystopia or utopia. Thank you very much.
Thank you, Nicola. I was wondering how pets share the internet, and we've just heard how pets share the internet. Our next presentation is a dual one. Dr. Amanda Reilly is a senior lecturer in law at the School of Accounting and Commercial Law at Victoria University. She teaches across a range of commercial law subjects, but her main research and teaching interest is in the regulation of work with an emphasis on human rights and social justice concerns. Amanda is an associate of the Centre of Labour, Employment and Work, CLUE, and the Secretary of the New Zealand Labour Law Society. With Amanda is Kathleen Makale, and I hope I'm pronouncing your name correctly. Kathleen, please forgive me if I'm not. Kathleen is a lecturer in the School of Accounting and Commercial Law at Victoria. She's currently lecturing in the areas of financial accounting and taxation. Her primary research interests relate to the intersection of accounting and/or tax policies and society, including critical evaluations of the impact of such policies on society and the environment. And currently, Kathleen is working towards her PhD completion, which explores how accounting could be opened up and broadened out through the exploration of contested notions of engagement and accountability. So, Amanda and Kathleen.
Okay, well, tēnā koutou everyone, I hope you can hear me. Since this is quite a short presentation, I'm going to be painting with quite broad brush strokes. But you'll notice at the bottom of that slide there is a link to a short paper that Katie and I have written, which provides more technical detail. I also want to emphasise that if you have any in detail technical questions about taxation, these are not to be directed to me, but instead to my learned colleague. So that introduction, and I think it actually, what we have to say follows on quite well from some of the things that Nicola touched on previously. As we're all aware, COVID-19 has precipitated a large increase in numbers of people working from home. And what we don't really know yet is to the extent to which this is going to be a permanent thing or not. So what we are honing in on is the fact that there are costs to working from home. So these include things like power, internet, the space in the house that could be used for other purposes, and office equipment. So I'm going to just take a little digression just to root this in real life experience. If you can see on that slide there, that is actually my working from home setup. I took that photo the day that lockdown was underway. You can see my new computer, which was delivered just the day before. because I knew that I was going to have to suddenly start delivering 2 courses online. I didn't really know how to use Zoom or any of the things like that, so Andrew was referring as well to those challenges. So that was my setup. Had I known that I was going to be forced to work from home when we bought the house, I probably would have held out for a study with a door. But as you can see, I didn't have one, so that's my cat helping with the working. So you might be wondering, well, who paid for all those things in that office? And I can tell you very briefly, it was me. Okay, so I paid for that computer, I paid for that power, I paid for that internet. So some of my friends I've told this to were actually a bit surprised. They were saying, well, didn't your employer give you a laptop to take home and do your work on? And the answer is no. Another friend of mine, her employer gave everybody in the office $400 to offset the costs of working from home. There's nothing like that from my employer. Instead, I got to read a steady stream of emails about the dire financial situation, also reports in the media. This isn't confidential. You will have probably seen the various press releases about the dire financial situation. So I could theoretically have asked my employer to reimburse me, and that's what a number of people have said to me, you know, well, why don't you do that? But the fact is that I didn't, and there are a number of reasons why I didn't. One of those reasons was just with the environment of cost cutting and threatened redundancies. It didn't really seem like a good time to, you know, put my hand up saying, can you reimburse me some money for my expenses? Another reason that I didn't was because I was aware that employers actually don't have a legal obligation to reimburse their employees. They can if they want to, but they don't have to. But the final reason why I didn't was really because it was a low priority. So COVID-19, it was very sudden. It was just a crisis situation. Everybody I worked with was incredibly stressed out. We were all doing our best to try to deliver for the students. And I just didn't really feel it was appropriate to be difficult at that juncture. Okay, so that is a response to an emergency situation. And maybe in that context, I can deal with the fact that perhaps I paid those costs and I'm not going to make too much of a fuss about it. But what happens if the move to working from home is long-term? If we've seen new social change, which is just this is how it's going to be, well, who then is going to pay the costs for it? So one option might be employers. And I personally do feel that if employers are supporting the move to working from home as a tool for cost cutting for themselves, we need to be very clear about the fact that some of that cost cutting is coming from the fact they've actually transferred costs to their employees. So I would personally be less keen to subsidise my employer's long-term cost saving by me just spending more of my wages on those things. So there is a case in Switzerland and some jurisdictions, I believe, that employers are actually being compelled to reimburse their employees for the cost of this. So the Swiss case I'm thinking about, the employer had to contribute something to the cost of the rent of the employee's home. So that's really my question, or our question, who's going to pay for those costs, employers or employees? But at this juncture, I'm going to move to the second column on my PowerPoint slide. What you don't see there is a photo of my husband's home office. There wasn't room to put it on the slide. What I will say about that is it is actually bigger and it does have a door, which may point to some interesting gender dynamics. But actually, part of the reason why he does have that is because he's actually self-employed and he runs a small business from home, and he's registered for GST. So both working in the same house from home. What is the difference between us? Well, he can actually claim back the GST on things like computers and so on when he gets them. And a number of people who I actually thought, you know, I was quite surprised said, well, can't he just claim the GST on your computer and you can shut up and stop whining? But he refused to do that because it would not be ethical, which is true. And the other thing, so apart from being able to claim back GST, he can actually claim back a number of other things. He can deduct expenses against his taxable income. So costs of internet, depreciation on capital items, expense of the percentage of floor space of our home that he's using. So this, I think, is kind of strange. So somebody who's self-employed, because me as an employee, my only option is to ask my employee to reimburse me for those things. But somebody who's self-employed working in the same house gets all this extra ability to claim deductions from IRD. Another thing which I found when I looked into this is that a number of employers have actually reimbursed their employees and want to, but the process that IRD has set up is actually very complex and very difficult for employers to do this. So they
one minute, Amanda.
I'll get there, don't worry. So they introduced a so-called simplified process, which I'm not going to try to explain because I don't think it is simple at all. And this was extended till September, but apparently this was a specific response to COVID-19, and it's now available until March. So anyway, just going to our final points here, I think that if it's going to be a long-term thing in New Zealand, we do need to take a look at our tax system. One, I think we should simplify the reimbursement process for employers who want to reimburse their employees, leaving aside the fact whether they could be compelled to reimburse. The other thing is, why not allow employees to directly claim tax deductions for expenditure incurred in the course of deriving their income? I think this would be fairer. And also when we looked into this actually is the law in other jurisdictions. So I don't know if there are any Australians here, but it is much more straightforward for Australian employees to do this. And in Canada and Germany as well, we've been told. So in conclusion, I think that if it is a long-term feature, that in New Zealand we do need to take a very close look at our tax system. So that's the end.
Thank you, Amanda and Kathleen. You mentioned that Kathleen will happily deal with tax questions. There's one that's come in from someone called Donald, which says, can I claim as tax deductible my $70,000 spent on hair tinting and hairdressing? We won't expect you to answer that. Our next presenter is in fact the organizer of today's seminar, Dr. Anik Masalo, who is a professor of law at the University of Canterbury. Anik's research interests focus on gender equality, work-life balance, and employment rights in a comparative context. Anik is the author of various works, including Reconciling Work and Family in EU Law and Policy and Caring Responsibility in EU Law and Policy, Who Cares? Anik is the Vice President of the New Zealand Labour Law Society and will speak to us today on the topic of who works and who gets paid. Anik.
Thank you, Graeme. Kia ora koutou. Oh my goodness. So I'm moving on to this analysis with a gender analysis, in fact. So the COVID crisis has highlighted that women play a huge part in the economy. Gender issues are at the core of the pandemic, and so I'm always having a gender lens when I'm looking at this. This has challenged our way of understanding the meaning of work. And the meaning of work does not just mean production recorded in traditional accounting. The COVID-19 pandemic has revealed huge inequity in terms of work. And we've seen in the June statistic that out of 11,000 jobs that were lost, 10,000 were in fact lost by women, which prompted people to talk about a pink collar recession. What we've seen during the pandemic, well, what we've seen during lockdown essentially is that productive work for women has been more dangerous and less rewarded than for men in general. Women represent the majority of health and social care workers. They were at the forefront of dealing with the pandemic, and therefore they ended up being the most affected and infected by the virus. The essential workers are also the supermarket workers who have had not only to be at work long hours, but also very little reward. On average, minimum salaries, they have received a 10% pay increase on a minimum salary, which has been taken away once lockdown was finished. And I'm not even talking about other vulnerable workers like sex workers who have had to work relatively unprotected. In the meantime, care has continued to be invisible and unaccounted for. Women have not only continued to do the vast majority of the care, but in addition, they've had to look after children and others while school and nurseries, etc., have closed. In addition, there are some statistics that show that women also have had to service their partners while on lockdown, and that also represents, well, I'm talking about sex essentially, and that essentially that represents some form of work that is unaccounted for. Linked to that, there is an increase in domestic violence and increased violence at work, in particular in supermarkets. And with all that, we can say that there are all sorts of women, and there are women who are suffering even more from these inequities, particularly Maori women and Pacifica women, where we have a higher risk of unemployment because of the sort of work in which they're working in the economy. Also increased risk to exposure to the virus because we have overrepresentation in aged care sector and a substantive level of care responsibility. So what have we had? We've had a response from the government that is sort of two prongs. The first part of it is shows that actually our understanding or the understanding of the government is still very archaic, and it's still very based on men. It's about public space, it's about the work. So basically the Shovel Ready project is about a recovery that is framed in order to improve the outcome for men. There is no gender analysis to that recovery. However, we've also seen another aspect to the response of the government in terms of violence. So there's been quite a lot of fund that has been put forward in order to support the Domestic Violence Victim Protection Act 2018, and this is with a view to support a long-term approach, which includes even service for the perpetrators. So this has been really quite interesting. And there is, of course, that bill on the protection of the first responder, which is still in front of Parliament at the moment. And which includes some criminal sentences for violence against healthcare and emergency workers. What I'm claiming is that, sorry, I'm trying to move the PowerPoint, but everything is on this PowerPoint. What I'm claiming is that we should think about in the post-COVID environment, we should think about a different way of thinking about work. And this has been started a little bit with the Ministry of Work, which has started to instrumentalize some tool in order to have a gender approach to implementing some policy. And this is the emerging of some form of gender mainstreaming in New Zealand. So flexibility has been at the forefront of what has, at the forefront of the pandemic. We have had some major physical transformation of the workplace. Flexibility is in it, and Prime Minister Ardern talked about the possibility of maybe moving to a 4-day work week. In fact, we need to go a little bit further than that, and we need to think about the diversity of the workforce in New Zealand and the diversity of women in New Zealand, because not only people would like to have or would benefit from vertical time reduction, so a 4-day week, but also possibly an horizontal time reduction, which would consider a shift with fewer hours, or maybe some people are more happy working from home altogether. On the whole, what I'm saying, not just for New Zealand, but for, the work that I do in Europe, is that we need to have a feminist approach to work. where we take a holistic approach and a feminist approach to work, which would include unpaid care. So we really need to include unpaid care in the meaning of work. And we need to have some strong fundamental value and an ethic of care, which would include a view of people's relationship as being really important to our human being connections, but also which would take care of people's cycle of life. And I'm just going to leave it at that. I have written a paper with Maria Hayes, which is going to come out in the New Zealand Journal of Employment Relations, and this develops on this issue. So if people want access to this paper, I'm happy to send it away. Thank you.
I'm so sorry, you're on mute.
Now I'm not on mute. Thank you. Thank you, Annick. Our next presentation is another dual presentation. Anna Sturman is a PhD candidate and a sessional academic in the Political Economy Department of the University of Sydney and a doctoral research fellow at the Sydney Environment Institute. Her research focus spans the political economy of climate change, labour and nature and the capitalist state. With her in this presentation is Matt Scobie, who is a lecturer at the School of Business at the University of Canterbury. Matt's research interests are broadly around exploring ways to hold organisations, businesses and governments accountable for their social, environmental, cultural and economic impacts. This is geared towards imagining and creating positive and just futures, including a specific focus on Indigenous development, decolonisation, corporate social responsibility, and social environmental accounting and accountability. So, Anna, are you going first?
Yes. Yes. So I am coming to you today from Sydney on the land of the Gadigal people of the Eora Nation, and I'd like to take a second to pay my respects to elders past, present and future on this land in accordance with the traditions of Australia, so-called Australia. So I'm actually speaking to you on behalf of Dr. Matt Scobie and myself about a paper that we wrote together for the same forthcoming issue that Annick just spoke about. And our paper is called Economies of Mana and Mahi Beyond the Crisis. Matt is lecturing right now, which is why he's not here. But Matt is Ngāi Tahu and I am Pākehā, and we see the authorship of this paper as based in treaty partnership. So it may seem odd that I'm presenting it, but I come with his blessing. I'm allowed to be here doing this. So the paper itself brought together our research interests because it marries empirical analysis of the latest developments in Aotearoa with some of the latest theoretical advances in accounting and political economy, which are our respective disciplines, as Graeme just said. And if the bells haven't started ringing yet, yes, we're the radical people here today. And I come from a materialist, ecofeminist tradition, again, sort of similar to Annick. So I'm going to quickly skate through the structure of this paper and then talk to one of the themes that runs through it as one that I hope is of interest to this group. I should also say briefly that I am a lawyer from New Zealand, so I have been very interested in hearing what everyone else is up to as well. So in this paper, we explore the horizons of economic change that COVID-19 has, however briefly, brought into view. We explore these implications of COVID-19 and its response for employment in Aotearoa, New Zealand, focusing on the potential effects in Māori communities. To prevent the foreclosure of alternative futures, we emphasise the need to envisage economies in different ways and the potential for alternative understandings of work within these visions. So as our entry point to these discussions, we explore the history of economic restructuring in New Zealand and the ways in which Māori have been disadvantaged within these broad programs of change. We then discuss the treaty and the implications for Māori economies within this, and then delve into alternative understandings of work, employment, and value within Māori economies, and how these have played out in the contemporary crisis. We do so to open up the potential for multiple futures based on diverse conceptions of work and value. We conclude with opportunities for future research and practice and argue that now is a crucial time to think more carefully through treaty partnership and alternative economies and employment. So the theme that I would like to dwell on briefly here is not the intricacies of Māori economies, which is much more Matt's area of research and expertise, but more generally in my area of expertise, which is on transformation of economies and relatedly the concept of work. I think where we end in our paper, which I haven't linked to here, which was a mistake, but maybe I'll be able to find it and send it through on the chat function afterwards. But where we end in our paper speaks to the moment that we find ourselves in, and where many of the other industrialized economies are at, in terms of being searching for transformative ideas, trying to find our way through. So we can see this in growing discourses locally and internationally around Green New Deals, universal basic incomes, job guarantees, degrowth, circular economies, and an interest in what Marilyn Waring began talking about decades ago, reproductive labour and the unvalued work required to sustain the quote-unquote productive economy. These ideas all involve a pretty radical reconfiguration of the idea of work as they move different macroeconomic levers. In Aotearoa, we must navigate these ideas in light of the treaty partnership, as we discuss in the paper, and the structure of our own export-dependent Pākehā economy and labour force, which at this point is theorised almost exclusively within orthodox traditions and limits. Many of the discussions about work and employment going on right now are geared towards restarting or turbocharging the productive economy, sometimes with a nod to environmental protection, but we do run the risk of racing right past one of the most interesting insights of COVID, grasped by many for the first time, which is that the labour that must continue no matter what is not always valued or seen, and it is most definitely not productivist, but largely reproductive in its function. Perhaps in this moment, there are some generative openings for theorising our economy and work in new directions. So in focusing on economies of mana in our paper, we've gestured towards one of the frontiers of transformation particular to Aotearoa. We have also gestured to the significant periods of economic transformation that have marked our colonial past and how contingent these outcomes have been, how they've turned on contestation from opposing forces, opposing social forces, and how the state form has then undergone periods of restructuring as a result, in turn delimiting or expanding the possibilities for further contestation. And I'd say we're probably at a bit of a low point right now in terms of how we're able to contest things. In terms of the moment we find ourselves in, what comes next for Aotearoa's economy and workers will depend on the willingness to engage with these big transformative ideas that are springing up everywhere from international labour, social and decolonial movements, and to connect them to the transformative ideas from here, grown here, built from our communities, while navigating the current constraints imposed by our institutional architecture. The point, Matt and I think, is to look at our history with an eye to the future, to consider how we learn from our past while looking to the horizons of contemporary change. The paper that we've written is only one small contribution to building these connections, which we hope continue to grow beyond this time of crisis and into our shared future. And that's me.
Thank you, Anna. And you have set a record that you've come in under your 5 minutes. Thank you very much. And please pass on our thanks to Matt for his part of the contribution. Our next speaker is Dawn Duncan. Dr. Duncan is a lecturer in the Faculty of Law at Otago University. She teaches and researches in the area of labour law, work, health and safety, accident compensation, and social security law. And not surprisingly, Dawn is going to be talking to us about worker health. Dawn.
Okay, that's me unmuted. That's a good start. I do have 3 slides. And I do have to apologise. I started with 7 slides, but Anik said you must reduce. So I have at least attempted to reduce to 3. So I wanted to talk about this idea of, are we at dystopia or utopia? We're definitely not utopic. If we are utopic, I haven't seen much evidence of the utopia. But then I also thought we're not particularly dystopic. I mean, no more than normally capitalism might be described as dystopic. In terms of workplace health and our legal responses to workplace health, it's not quite a dystopia, but it's still pretty bad. So what I'm going to talk through are the things that I would really like to see improved, the things that COVID-19 has highlighted for us as being particularly out of date, particularly inadequate, in the hope that this becomes a time when we might generate a bit more interest and hopefully a bit more political will to address some of the problems that we're going to have even more of in future. So if I can get this slide shifted. What I'm going to talk about is sick leave, ACC and the Health and Safety at Work Act. I could also include their personal grievances because personal grievances operate to sort of plug some of the holes, but I'm just going to look at these particular three. So employment lawyers will be well aware that sick leave questions are abound at the moment. When we went into lockdown, there were a huge number of questions about what are we supposed to do? Can you take sick leave for this? Can you not? Can you force an employee to use accrued sick leave? And we've also seen governments campaigning on an extension of sick leave to 10 days. What I would like to argue is that we need more than just an extension to 10 days. Our sick leave provisions have some pretty fundamental problems with them. The first is that it lacks any clear policy goal or policy principle. Workers' health generally suffers a bit from a poverty of philosophy. When I told my colleagues I was writing a paper on the philosophy of sick leave, I'm pretty sure they thought I'd hit my head and needed some kind of medical attention myself. But if you think about it, for law to be able to develop, you need some sense of what you're trying to achieve in that law. And what are we trying to achieve with sick leave? Is it we have sick leave because it's a worker's right under ILO instruments? Do we have sick leave because it's a fundamental human right to health? Is sick leave about ensuring capacity to perform work safely such that it's a kind of impairment focused entitlement? Is it about reducing the spread of infection in a workplace? Is it about encouraging health or well-being more generally? Is it all of the above? Is it none of the above? And the reason that it matters is it's really hard to develop the law if you don't know what you're trying to achieve with it. Associated to that, our sick leave provisions lack a whole bunch of machinery around sick leave. In terms of things like an obligation on employers to ensure there's enough cover for people to actually take sick leave. What we know from the data is that half of people don't take sick leave even though they have an entitlement. What's going on there that they can't feel as if they can take sick leave? Do we have issues around people working from home when they're sick instead of taking sick leave? We need some additional clarity around sick leave use. And to get that additional legislative clarity, we need a coherent set of goals. We also need sick leave to connect to the other areas, ACC and health and safety at work. ACC, we have seen, has inadequate cover for workers' health. If you contracted COVID-19 at work and you're a COVID-19 long hauler, you have no cover. We have really poor provisions for infectious diseases, and that affects workers in agriculture who are working with animals and contract diseases there that effectively turn into pandemics sometimes. We have no cover for sort of chronic mental health problems. We have extremely limited cover for chronic health problems generally and none for chronic stress-related illnesses. We have inequitable cover in terms of female-dominated industries who, as Anik mentioned, are pulling the bulk of the labour in the pandemic. We have no data, which means that if we have no cover, we have no data. So we have all of our injury and illness data in New Zealand collected from ACC administrative data. If we have no cover, we have no data. We can't see what the holes look like to be able to address them. And I've got 10 more seconds. My last point on the Health and Safety at Work Act, we don't have the legislative machinery to inspect or enforce in relation to complex health problems. We barely had the machinery necessary to deal with the COVID-19 pandemic. And if we're going to deal with things in future, we need significant changes in that respect. So is there a path to utopia? No, but we could at least significantly improve things quite a lot for a lot of workers through substantial legal reform, starting with clear goals and a strong principle basis for those laws, connection between the different areas of laws so that they're all working towards the same goals, and laws designed for the work that we're actually doing now by the workers who are actually doing it. And that's me.
Thank you, Dawn. I suspect that the next 2 weeks is probably not going to be the best time to get traction on any of these very important issues while we grapple with the more frivolous. But long term, many of the ideas that many speakers have had, including Dawn's, are well worthy. We have another joint presentation. Dr. Sana Malinen is an Associate Professor of Organisational Behaviour and Human Resources Management at the University of Canterbury in Christchurch. Sana's background is in organisational psychology. She researches in areas of workplace resilience, employee well-being and disaster management. Katarina Naswal is Professor of Psychology also at Canterbury University. Katarina's research focuses on employee well-being and factors which lead to psychologically healthy workplaces, including psychology. She's worked on several projects on psychosocial recovery after disasters, focusing on how business can play an important role in individual and community recovery. She's currently conducting research on how organisations and managers can make a positive difference and contribute to employee well-being. And their presentation is entitled succinctly, COVID and Wellbeing. Sana and Katarina.
Oh, kia ora, Graeme. Tēnā koutou katoa. Graeme, you did an excellent job at pronouncing both of our foreign names, so thank you very much for that. So many thanks for this opportunity to talk a little bit about workplace well-being during COVID, and hopefully this is also relevant to other types of crises and disruptions. As we know, there's a lot of uncertainty at the moment in the workplace, and uncertainty, like feelings of job insecurity, can really have a detrimental effect on employees' performance, but also their well-being. Workplaces can, however, play a really instrumental role in supporting employee well-being by having a positive or a supportive workplace culture. So both of our backgrounds are in organizational psychology. We're not lawyers. We do research and work with organizations from a positive psychology perspective, which you'll hear from our presentation. We try to make people to have more good than bad days at work, and workplace culture has a lot to do with that. So we know from research that positive social interactions are key to conducive workplace cultures, cultures that enable higher performance, they enable more resilience in employees, they enable resilience and well-being in all of us. And a really good indicator of positive interactions is what the prevalent communication style is in teams, is in organizations. So how much kind of affirmative or positive supportive language people use. And research is very clear in showing that one of the key aspects in predicting organizational performance is the ratio of positive to negative statements. A lot of research has looked at this in high-performing organizations, have found that, for example, in high-performing top management teams, the ratio of positive to negative statements is around 5.6 to 1. And it actually turns out that if you have a ratio about 3 to 1 positive to negative statements in any kind of interpersonal relationships, that relates to a whole bunch of positive outcomes. We tend to live longer, we tend to make much higher quality decisions, we're more flexible, we're more creative in our thinking. People even stay married for longer. So more positive to negative statements. And one of the key factors to achieve positive interactions in the workplace is to do with kindness. So I'll hand over to Katarina, who will talk a little bit about this.
Kia ora, Sana. Kia ora koutou. I'm really happy to be talking about kindness because we see this as a framework that can be used to support these positive interactions in the workplace. So often we say we're in a situation where we actually can't give these positive statements. But if we think about the kindness as a framework and why that actually has benefits, and I'll try and convince you in just a minute. So when we're exposed to kindness, there's a physiological reaction that makes us less stressed and more positive in general. So it makes us more likely to engage in kind actions ourselves. It also, because it reduces stress, it actually takes a little bit of pressure off us in terms of stress reactions. So we become better at thinking. It frees up cognitive resources, and it makes us better at what we do. And kindness is good in another way, is that it doesn't just affect the person who receives the kindness, it also affects the giver and observers. So here's where we think there's an opportunity for people to contribute to these positive interactions. And we're also talking about survival of the kindest. Those who are typically kind in history or in general have stronger social networks, which then in the long run help them succeed. And we'd like to sort of challenge a little bit and say that we should also be talking about systemic kindness and how the systems we work in, the organizations we work in, support kind actions. Are we able to be friendly to each other, or is the system we're working in actually preventing us from that because of structure or culture? So kindness should be part of our culture and the way we do things around here. And it should be inclusive so that all groups feel that the system works for them. So with that, I'm going to pass you back to Sana, who will put an even better challenge to you.
My apologies. Can you hear me okay? Kathy, can you just give me a thumbs up? Yeah. My laptop just died, so I assume.
No. Are you happy to?
Yeah, absolutely. So yeah. With a lot of leadership groups is we like to end with a bit of a call to action and challenge each of you to influence the culture in your team or in your organization. So we like to give you this Monday challenge and ask you to ponder about one behavior, perhaps an act of kindness, perhaps a few more positive statements at work that you can do on Monday to enhance the culture and thereby the performance of your team. So we'll leave you with that challenge and hand it back to Graeme. Kia ora.
Kia ora, Sana and Katarina. Our last speed date is with Peter Upson. Peter has LLB and LLM honours degrees from the University of Waikato. He's published in the Comparative Labour and Social Security Law Review. He's a former First Union delegate and is currently a committee member of the Labour Law Association of New Zealand and works for the Public Trust. Peter.
Thank you, Mr. Colgan. Kia ora, everybody. It's ironic to give a presentation about COVID-19 over Zoom, but there we are. Just open up my document here. Start my timer. Artificial intelligence is being used to detect COVID-19 in the workplace throughout the world. The data collection mechanisms for this vary from next-generation cameras with thermal imaging and facial recognition capabilities to software applications that conduct contact tracing and measure social distancing through GPS, Bluetooth, accelerometers, and gyroscopes, to wearable smart sensors that measure temperature and heart rate, to the ubiquitous installation of sensors in everyday objects. However, their common feature is that they process their data using artificial intelligence to determine if someone has COVID-19 or is complying with COVID-19 restrictions. For professionals involved in employment and labor law, it is important to understand first how these devices work, and secondly, how they are governed by the information privacy principles within the Privacy Act, and finally, whether any exemptions may apply. First of all, in relation to next generation cameras, a Christchurch care home recently became the first in the country to install thermal detection cameras along with a constant thermal heat source. Thermal cameras are as accurate as thermometers, but they lose accuracy as the room temperature changes, for instance, as people enter and exit it. Therefore, the use of the constant heat source allows the camera a reference point to automatically recalibrate its temperature. In terms of software applications, there are a number of very interesting ones. The first is called Check-In. It was originally designed and developed by PricewaterhouseCoopers to monitor workplace productivity, but it has been repurposed for contact tracing for COVID-19. It activates Wi-Fi and Bluetooth capability to track workers throughout a workplace premises. Several companies have gone away from the use of smartphones and now are using instead machine vision software. An example of this is SmartVid, which is a prominent Canadian construction supplier of IT, prominent supplier of IT products to the Canadian construction industry. And it claims that its technology can help organizations identify and log the number of people not adhering to social distancing rules, and it can even recognize when people are failing to wear protective masks. Finally, Amazon recently released its Distance Assistant, which monitors people's workplace location and provides instant visual feedback on their screen as to how proximate they are to other people, which helps enforce social distancing guidelines. In terms of smartware, recent innovation in New Zealand has been a device called Nightingale, which is a matchbox-sized body sensor that's worn under the armpit, and it provides constant monitoring of body temperature, which is streamed back to an AI program that measures when residents of old age homes and hospitals come down with fevers. Moving on to the Internet of Things. Almost all Internet of Things devices were designed initially for the mass consumer market, usually as luxury products. However, they seem to be purpose-built for also helping in contact tracing. For example, in 2014, there was an outbreak of dengue fever in Singapore, and they used what is called geographic information system data from Internet of Things devices such as cars and microwaves, and overlaid it with mobile data to locate patient zero and then to contact trace everyone they had come into contact with. The final example is from another Canadian company called Blackline Safety, which originally developed wrist bracelets that were used to measure gas leaks. But then this was repurposed to be used in contact tracing and temperature monitoring. So how do we, in terms of New Zealand law, how do we lawfully record people's actions at work, and what exemptions could apply for COVID-19? So to legally surveil people at work, we have to comply with the information privacy principles in the Privacy Act. And in summary, it has to have a lawful purpose connected with a function or activity of the employer's business. It can only collect information necessary for that lawful purpose. Employees must be aware that the information is being collected, the purpose for it, and the intended recipients of that information. The information must not be collected in an unlawful, unfair, or unreasonably intrusive manner from the employee. It must be stored safely and securely for no longer than is necessary. Employees must be aware of where it is stored, have access to it, and be able to correct it. And the information can only be used, disclosed for the purposes for which it was collected. In the context of COVID-19, there are a number of exemptions that may allow for the sharing of personal information. First and foremost, the information can be shared if the employee concerned authorizes it. Secondly, the Privacy Act is purpose-driven. Personal information can be shared if it is the same or directly related to the purpose for which it was collected in the first place. This exemption will often apply to information about an employee's COVID-19 exposure and risk. A key reason employers are seeking this information is to enable them to take steps to keep their workplace safe and others safe within the workplace.
1 minute.
And finally, 10 seconds. There is an exception within the Privacy Act principle 11, that allows for the sharing of information if it is necessary to prevent or lessen a serious threat to public health or the life and safety of another individual. Thank you.
Thank you, Peter. To mix my metaphors, capitalism never lets a good crisis go by. And is 2020 the new 1984? That concludes our presentations, and there's been a wealth of condensed information presented to us, any aspect of which will probably warrant a whole seminar. That may be for the future. We've got about 10 minutes, and we've got some questions. Would you be able to read those out and ask for answers from the presenters whom they're directed at, please?
So there's been some discussion on the chat. There's been two main questions. One was from Irena to Nicola, and it was about what about the health and safety issue of working from home? And the other question, which was from Lynn to Amanda, which has generated a lot of chat, was about if an employee doesn't have the cash flow ability to purchase equipment to work from home, will they be considered not ready, not willing, and able to fulfill their employment obligation? So maybe Nicola and Amanda, you can start dealing with that. I know that John has contributed to some of this discussion on the chat.
Yeah, sure. Just in terms of the health and safety aspects of working from home, I did mention that in part of my presentation, and certainly it's an important issue, and the employers have the same obligation as they do to anyone to meet the requirements of the Health and Safety at Work Act. And that's actually, in my experience with consultancy, with organisations working through these issues currently, is trying to work out how they can do that. For example, many office-based employers offer sort of work site assessments to people who are at work to make sure that everything's okay, and how can they then do that at home to provide the same thing. And that kind of leads into the same question that I also posed about who pays for what. And that was the discussion in the chat also. And the answer to that is, well, it depends on what you have agreed to and what your agreement policy is. And certainly what I found through my research post-earthquake is that people were willing, as Amanda was, to put up with having to, sort her own stuff out during a crisis, but how that then plays out in the future sort of remains to be seen. And certainly from experience that I'm seeing around me is that employers are working out what that means and what they will provide, and often it means taking equipment from the office or offering a reimbursement to buy your own furniture if that's required and you want to continue to work from home. And it all gets down to being a bit of a balance between what personally are the advantages for you to work from home and what are the costs, particularly when it's voluntary. That's another key thing, whether it's mandatory, whether, and like in COVID, it was interesting because people had to work from home. It was compulsory if they could. Not everybody could. And now when you're returning to BAU, it becomes something that people want to do. So where that sits in their agreement.
Just adding to that point, if I may, and working from memory, I seem to recall that the Employment Relations Act requires, as a minimum, individual employment agreements to contain a description of where the work will take place. I suspect that some, but not all, will have either anywhere in the universe or including at your home. But if they don't, and an employer says, I'd like you to work from home, the response may well be, well, that's interesting. You'd like to vary my employment agreement. Let's negotiate about that, the terms on which we're going to have that variation. So there's an argument as one way to address that, perhaps. Annick, we were going to follow up with another response, weren't we?
Yeah, Amanda, did you want to contribute to the question from Lynn about if the employee doesn't have the cash to purchase the equipment to work from home, will they be considered not ready and willing and able to fulfill their employment obligations?
Well, I can't really answer that question because I don't know what the answer to it is. I don't believe that employees can be required to go and spend their own money on buying equipment. Just a point following on from what Nicola was saying about the difference between if you choose to work from home and if it's compelled. The Canadian tax system, Katie can tell me if I'm wrong about this, but you get to claim deductions if you're required to work from home. So it's not if you just choose to work from home. And similarly, that Swiss case I was talking about where they forced the employer to contribute to the cost of the employee's rent. Again, it was a case where the employee was required to work from home as opposed to choosing to work from home. So I think there's an important distinction between whether it's a choice, whether it's required. That's all I've got to say.
Thank you.
Thanks, Amanda. Are there any other questions that anyone would like to contribute orally at this point? We'll leave a slightly longer opportunity than usual if we were together because people need to turn off their mutes and contribute. All right, it doesn't sound as though there are...
John wants to ask a question.
Sorry, John, okay.
John.
Sorry, I just wanted to sort of make a follow-up point around those previous points, if I can. One around the health and safety at working from home. The other point there is ACC cover. If you're injured while working at home, is something for people to think about because the cover for work-related injury and the cover for at-home injury is distinct. So you may get ACC refusing to cover it and saying that it's not in fact a work injury. The second point is around, we have provisions that say you can't require as a matter of contract somebody to purchase health and safety equipment if they're an employee. So if you're working from home equipment as health and safety related equipment, you might be falling foul of the Health and Safety at Work Act. Also, you're potentially falling foul of the Wages Protection Act if there's nothing in your contract about that one as well.
Any other questions or contributions? All right, Anik, we've almost reached 4:30, which is our cut-off point. Just on behalf of everybody, the 39 people who are still online, and there were more than 50 at one stage, I want to thank you for organising this, for doing a presentation, for multitasking, including doing the slides. As I said a moment ago, there's been a huge amount of information run past us in tantalizing ways that we could pick up any aspect of and have future seminars. But we really appreciate references to articles that people have written, and I'm sure that we will come back to some of these topics in a similar seminar. So thank you, Anik, for organising that on behalf of everybody.
Thank you for everyone to join and to contribute. So if I've just put the last slide, if people want to have the video, wants to share the video afterwards, it will be put on the New Zealand Labour Law Society. Thank you, Graeme, for chairing this seminar.
Thank you. Goodbye, everybody.
Goodbye, everybody.
Goodbye, everyone.